What's up, everybody? Sometimes expert days can be really entertaining, enjoyable, educational. Sometimes they can be miserable. Personally, I enjoyed today. I felt like we learned of a lot of important details, how the state was going to present them, if the defense is going to pick at the edges or kind of go full bore at them. We learned a lot about that. We finally got some accident reconstruction. We haven't gotten cross on it yet. We've got craziness in the beginning of the day, voir dire at the end of the day to see if there's shenanigans going on with the Commonwealth. We got everything you could ask for in day 25 of the Karen Reed trial. We're going to recap, react, break it down, answer your questions today. I was like, hey, why is this intro taking so long? And then I realized I hit the outro. John, can you guys fix that? Is that possible to fix post video? If so, please do. So we're here. It's not over. We're just beginning. The fastest episode everybody's saying. I just clicked the wrong button. That's all that was. So a lot of people saying they thought today was the most boring day ever. I disagree, mostly because I heard some stuff I have literally never heard before. I heard some stuff that I think I might put into practice potentially. Something that's going to change the way I look at certain evidence, which I always enjoy when that happens. I enjoy when I learn from watching these trials. I love watching trials because it always keeps me fresh on rules of evidence, objections, arguments, discovery rules, how to react to certain judges' calls, how to potentially change certain judges' minds, things like that. So I really do always enjoy that about watching trials. But today, I very much learned something new, and it's with this first witness. But before we get to the witness, the beginning of the day, the videos go down. We all don't know what happens. And rumors are, okay, and I'm just going to say rumors are and allegations. I don't really know what exactly happened, but rumors are a juror was shown on video. We're not going to go through it. I'm not going to look for it. I don't want to put any juror stuff out there. No reason for that, in my opinion. Doesn't do anything or add anything as far as to discussing this case from my perspective or what I'm doing. But rumors are that happened, and the judge shut down cameras, probably got a little upset about it. I get it. I would be too. Whose fault it was, I don't know if it's the cameraman's fault, if it's facing the same direction it's supposed to be facing the entire time. There was oversight. There were problems. Not great. But then I also heard the judge was interviewing jurors. So there's a couple reasons she could interview jurors. Number one, for this juror's safety, maybe she said, hey, do you want to leave? You were on camera. It's a high profile case. It's divisive. Do you want to leave? If you do, we'll excuse you. But then she was interviewing 2, 3, 4 jurors. So then when that started happening, people started throwing out allegations that jurors were going around to the waterfall, interviewing witnesses, talking to people, doing things that they should not have done. And if that's the case, if a juror really was doing that, they should be booted. And maybe that's why she was questioning witnesses. I don't know. When we came back, we got this horrible camera angle, which I said is better than nothing. And it is, barely. But when we came back with the next witness, cameras were fixed. So we're just going to have to suffer through here for one witness, and then we will eventually get to it. So this witness, good background. Seems like a nice lady, served in the Marine Corps. Thank you for your service. Always loving a witness has that as a lawyer from a lawyer's perspective. Military service and working for professional sports teams are two of the best things you can have with an expert. We had Tully slip in there. He did some work for the Patriots, like security, stuff like that. And then this lady, military, other people in the military. Hold on. Let me text John to just, clip it out. Okay. So she had that, which is always good. She was contacted by Tully in May. Specifically, she was asked to look at the 2 Google searches and, put them through all her programs and figure out what happened. And then also look to see, was anything deleted? Is there evidence that things were deleted? So a lot of testimony about, all the tools she uses and websites and how smart she is. And I thought it was great and it was fine. And I think that, she was fine and she seemed credible. But now we are going to get to some evidence that I have literally never heard anybody testify to before. It can be good or it can be concerning. And we're going to talk through it. And this raises some very important questions that both sides potentially are going to have to deal with in this case and, for the Commonwealth's sake, in future cases. So we're going to listen to, it's about a 10-minute block of her explain some of her opinions and how she got there. People are saying they don't explain a lot of what she said, and that's always problematic potentially for the jurors if they don't, pick up what her actual opinion is, which is why you do the background and then you really try to highlight what is your expert opinion. I like to do all the background, lay all the foundation in as quickly as I can, literally, and say, okay, now tell us what you were asked to do in this case and what was your opinion on what you were asked to do. 2 Google searches and was anything deleted? And here is my opinion. I like to tie a bow on it. I've tried to get it in here in this clip so we can listen to it, so we can all understand it, so we can discuss it.
That I'm showing in terms of what searches were searched where and when and what source of data they came from. So if we look at this first search, I have them in the timestamp order that is associated with the artifact. I want to clarify that we need to discuss the meanings of these timestamps as we go. So this first one that you're going to—
I had a feeling she might feel too fast, so I'm gonna drop it down just a little bit so we can understand it a little better.
See is, and I'm just going to reference my paper because of the size, is 0227 and 40 a.m. So that's 2 o'clock in the morning, 27 minutes and 40 seconds. And it is a search for the term HOF, long to die in cold. And that is timestamp in this instance is from the browser state DB, which is right here. The browser state DB is an artifact that speaks to when tabs are moved. So when you're using your browser and you open different tabs, you may have a search that this time pertains to the time that tab moved. It could be lots of things. It could be you switch tabs. It could be you close the tab. It could be you minimize the application. Depending on the version of iOS, what can be that browser state of the tab that changes this timestamp differs. But what's very special to know about this timestamp is that is not the time necessarily of the search.
Okay, so she is saying the time can correlate to when the tab is manipulated, either tab open, closed, put to the background, whatever. Okay. We all know anybody that has an iPhone and has done this stuff, you can manipulate tabs and move them around and, go to Facebook and then back to Safari or whatever, Google Chrome, whatever you use. And I get that. But then she says, it's important to note that it's not necessarily when the search was made. Words like that are really important, because she doesn't say absolutely not when the search was made. She said it's not necessarily when the search is made, and I'll play that back.
Know about this timestamp is that is not the time necessarily of the search. If a browser is opened and a single search is made, those will match. However, as long as that browser hasn't been closed, moved to the background, etc. If that browser has had any activity that happens to that tab in terms of application closing, minimizing, this can update. That is what that timestamp is for. This search term is always going to be the most recent search term in that tab. That means the last item that was opened in that tab was HOF long TI die and cold. We cannot tell by this particular artifact what time that search occurred. It is a high likelihood that tab was opened at this time because there was another search that occurred at 2:27 in the morning. It was a sports site. I cannot pronounce it. It began with an H. Hockenmock Sports. Hockenmock. Okay, thank you very much for the pronunciation. Hockenmock Sports. There were a couple of searches pertaining to that done immediately after, but it appears that that's when this tab was opened and the first search done there. So this search we know was done by this, and we know that it was the last search in the tab because it comes from this source, the browser state DB. And that means that particular timestamp and search pertains to what has happened with the tab. And that's what allows you to open your Safari browser on your iPhone and then open it on your iPad or your Mac and have the same tab. That's the function there. This search here, this is really interesting. So at 6:22:49 a.m., we have an entry in CacheDB that is specifically, if we dig into this URL, this is an Apple suggested term. So when you use a browser and you start to type a search you've never typed before, the browser tries to help you and say, are you searching for this? So as the user began to type the phrase in the immediate search after, which is how long TI to die in CKLD, this particular suggestion came up, indicating, in all likeliness, that the search term being typed had not previously been searched, because Apple suggested, instead of a previous search, it suggested how long does it take to digest food? After how long to...
So, and again, this is a question, I don't know, I'm just thinking about it as we're listening because I'm listening to it a second time. So if you type something completely wrong that makes no sense, it automatically pops up the next time you search something similar to that. That's what she's saying. I don't know if that's true or not, but that's what she's saying, because one of her proof pieces is this was not searched at 227 because the suggestion of, I can't remember what it was, like how long does your food digest, popped up, which shows it's the first time that's searching it. I'm interested to hear if the defense expert says something different. And if you remember, if anybody follows me on Twitter/X, is I said the defense needs to be really careful with this witness. Of course, some people took that as meaning one thing. Some people took it as meaning another. This lady knows what she's talking about. She knows how to explain it in the way that she believes to be true. So if you really start arguing with her, you can step in it. You can say something dumb. You can put your foot in your mouth, and you don't really need to if you have your own expert. So you just have to be careful. You don't want to do what I just did and say, are you serious? That's what you think? It pops up if you search it, even if you spell it wrong? Because the answer may be yes. And if she can shove that down your throat, then you're in trouble. So you just have to be careful with how you go at her. And is it really necessary? Let the state try to prove this. Let them put up an expert just to prove Jen McCabe wasn't searching this stuff, because they really know that's a problem. They're highlighting that evidence, as opposed to this has nothing to do with who hit who. Jen McCabe said she didn't search it. Now, I know why they put it up. I think it was a good idea to put it up, but it's not necessarily relevant to the accident, the reconstruction, the DUI, stuff like that. So just interesting, the different ways to look at this. And by the way, I posted that tweet before Cross started, and in my opinion, they were very careful on Cross, very careful, and he even made a comment about how careful they were being, which we'll listen to when we get to Cross.
Digest food had been suggested. The user then has a search at that time, 623.51, for how long TI die in cold, and that is coming from the mobile Safari plist, the com.apple.mobile Safari plist I mentioned earlier, and the search is also shown in the knowledge CDB. That's commonly what we would expect. We would expect that search to be in both of those, both that plist and that database. Then the,
can I stop?
Yeah, absolutely.
As far as the expectation of that being in both of those, the plist and the other database, why is that?
That is because the search is not being tracked not only by the plist for Safari, but also by the system itself to be able to do that predictive coding. So in the future, when you start to type how long, it gives you what you searched last time.
And with respect to that, how long takes?
Even if you spell it completely differently, that would have been a question I would want to know the answer to, but I'd rather ask my expert than her. And maybe if they already know the answer and it's not good for them, then you obviously don't want to ask this expert that.
Digest food. Based on your analysis, was that a search term that was ever entered into this one?
Correct. The source of that, if you look at this first line where it says CDN2 smooth.apple.
All the comments acting like they know what I'm going to say at the end of this testimony is funny. It's making me laugh. Stick around. Just wait till the end. Wait till the end.
.com. That's what indicates that this is an Apple suggested term, not a user input term.
I'm sorry, I interrupted you. If you could please continue with the next.
Absolutely. The next search that was done immediately after the search at 623, the next search was how long TI die in CLKD. Again, we see that search both in the knowledge CDB and the mobile Safari plist. And then we have, yes, we see it in both databases. Then, so that's how long to die in cold. Sorry, I was on the next line. Then at 624, we get the next search, which is HOS long to die in cold. And we have that search again, both in the knowledge CDB and the plist. If I were timelining this based on activity as opposed to timestamps associated, what I see here is the beginning of a user typing a search, Apple making a suggestion of how long to digest food. The user does not take that suggestion and rather inputs how long TI die in CKLD. They then make a second search of HOS long to die in cold. That search winds up being the last search in the tab, and that is why we see it in the this particular browser state DB. It should be noted that this is in one of those WAW files and not the raw file.
And so as far as...
So she's saying that she thinks the 227 search didn't happen at 227, but instead that was the first activity in a tab that was already open at 227 when they were searching about the basketball stuff. And when she typed in the house long to die or whatever, typed it in wrong, a suggestion came up of how long for your food to digest. Then I guess she erased that, typed in the how TI long to die in the cold, then erased that, and then typed the house long to die again and made the same mistake twice, first and third. That's what it sounds like she's saying. Sleuthy said, I feel like experts testifying as late as possible is best. I'd pay more money just for that. So I like to do a combination. Okay. And I get, and I know from seeing your name in here that you've watched a lot of trials. And for people that watch a lot of trials, I get that. You need a combination, in my opinion, in front of a jury that hasn't watched a lot of trials, because you need to go as quick as you can, 5 or 10 minutes of, I went to Harvard, trained at the Mayo Clinic, was the Patriots surgeon for 5 years, opened my own practice, and now have 10 doctors working for me. And I just love taking care of patients. You need 10 minutes on that for them to be like, oh, excuse me, Dr. Smith. Okay. And then get to explain what happened to this client's neck. That's what you need. And then in lay terms, as much as you can, to let them know whiplash hurts this way, busted disc, broken vertebrae, whatever, lay terms there. But you do need a little bit of the meat to explain to me why I need to listen to you in the beginning. Not unlike YouTube videos, right? It's like, I'm a lawyer. I do this stuff. I try these cases. It usually helps with the discussion than me just saying, as lay as I can, right? Jumping right into it. So I think a combination is most important, but I do agree with Jenny, this could have been done much quicker. So she is basically saying, you see the times, ignore the times. That doesn't mean it necessarily happened when the times say. A couple more minutes for her to finish her, main opinion on this part before I tell you why this is different than anything I've ever heard before.
Toward the top there, and I know we'll get a little more to this in a moment, but as far as that reading at 2:27:40 in the morning, as far as the timestamp associated with the search, why would that timestamp be associated with the search later on in the morning?
Because that table isn't showing the time of that search. It's showing the state of the database. So it's saying that the last time that tab was touched, moved to the background or foreground, was 2:27 a.m. The website, as you search more websites in the tab, that gets updated. So the current state that this is showing is that the tab was moved to the background or opened or some action for the tab at 2:27 a.m. when the Hawkmock Sports, I got it right, Hawkmock Sports website was visited. And then once the Hawkmock Sports website was visited, that tab was in continual use. There are other searches and activity that happens. We don't see that happens eventually. This search gets made at 6:23 a.m., this search at 6:24 a.m. That winds up being the last search in the tab. And because it's the last.
So it's very interesting. The 6:23 and 24, those are correct. Those did happen at 6:23 and 6:24, and she's going to explain why.
Search in the tab, that search at 6:24 a.m. That winds up being the last search in the tab. And because it's the last search in the tab, that's what the final update is and the final status.
So when you say last search in the tab in reference to time, in reference to what time specifically?
I'm sorry, I don't understand the question.
That question, let me rephrase. So as far as the 2:27 tab is closed, and then another search done at 6:23. Is that correct?
2:27 isn't necessarily when the tab was closed. That's in my report. I say that it's undetermined because there's a lot of things that can cause that timestamp to be there, including tab being moved, tab being minimized. I don't know exactly what caused the tab to get that particular entry, but it is not that timestamp is not indicative of the time of the search or any URL that's visited there. That time is indicative of movement of the tab, and the search is the most recent search. So they update at different times.
So I guess my question is, as far as from what your analysis is here, is there any use of that tab between, or is there any evidence or artifact of use of that tab between the 2:27 timestamp and the 6:23 timestamp?
So the fact that that timestamp exists at 2:27, combined with the fact that the only existence of this search is at 6:24, means that yes, that particular tab was used after 2:27 when the Hawkmock Sports was searched. I apologize for not being familiar with that name.
That's absolutely fine. Yeah. Now, if I could ask you at this point, you would talk about one in particular database having.
Okay, so that's generally her opinion, and let me tell you what I like about it and what I don't like about it. I like learning new things, and I think I can try to understand. You open a new tab, and that is some kind of, plot on your phone or whatever. It grabs the timestamp when you open that new tab. What I find hard to believe is that everything I do. So one of the other things I don't understand about this is, why is the 6:23 search showing up at 6:23, right? I get what she's saying about 2:27. That's when it was initially opened. And so for some reason, the second search, because the basketball thing was the first search. The second search was the Haas long to die in cold. So that caught on to the first end of the browser opening. But then the last search at 624 was the last search. So when they closed it out, we know that one was at 624. Why was the second to last one at 623? If she just went bang, 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 those last three searches, again, and this is confusing. I'm trying to dumb it down as much as I can for myself. Okay. So the first search, web browsers open. That's what she says grabs the time. So that's 227. That's basketball. Then the last search at 624, when the browser closes, that's what gets the 624 time. The two in the middle, in my opinion, should at least be in the beginning. They both should have shown 227, or they both should have shown 624, 623, whatever. It makes no sense that one middle search went to the beginning and one middle search went to the end, and two searches showed up 1 minute apart, but we're supposed to believe the one that showed up 4 hours earlier was 1 minute before the 623. That makes no sense to me. And I struggle. I always struggle, even with my own experts. Like, if a client, like I've had doctors say, a tap with no visible damage at all, and, it caused some brain bleed in a client. And I'm like, that doesn't make common sense to me. Can you explain it to me in medical terms and try to make me understand how that's possible? Because even if an expert has training and experience and is way smarter than I am, which I would just say all of them are, she's smarter than I am. If your explanation doesn't make sense, I am nervous to put it in front of a jury. That doesn't mean it's wrong. I just struggle when it doesn't make sense. And this to me makes absolutely no sense. What is the point then of anything we get from any Google search or anything from the internet with tabs? Not just that, if this was true and you had criminal defendants like Brian Koberger who are criminology experts and computer, whatever, and they knew about this and could manipulate it and be like, look, this search was at 227. The crime wasn't committed till 6 a.m. Obviously, it had nothing to do with it. Or vice versa. It basically calls into question the reliability of all of this. Is this what the Commonwealth wants to do? How often is the Commonwealth trying to say a search didn't happen at the time that it happened? I found it very interesting that they put forth this expert with this testimony and this evidence. So I learned something new. I didn't know that Google searches could be 4 hours off from something they searched just a few mere seconds before. If it's true, definitely something that could be used in for future cases and future trials. I'm going to have to, so what I do, just so you guys know, I'm not going to call her. We have our own experts we use in this kind of stuff. So what I would do is maybe send my expert this testimony and say, is this true? Could this help us here? Could this help us there? Now, most of the time in plaintiff's cases, if I have cell phone data and somebody's texting and driving or, making a call or whatever it may be, I want the time to line up. I'll just tell you, I've never, ever had this. Like if somebody's on their phone Googling something and it says they were Googling it, 30 seconds before the accident, I've never had anybody fight me on that reliability. So, and usually that's what I'm trying to prove. So I'm not sure how this would be helpful, but that's where I'm at with it. And again, of course, people on Twitter are like, well, there's the whole case. Anybody that believes this must be a moron. I'm like, okay. I struggle with people that say there's only one way to view anything. Because there are usually multiple ways to view anything. You can view this, believe it makes sense. You open a browser, it pings your phone, and sometimes your phone can get locked into that deadline. Okay, I get it. But I definitely think there's another way to see this, and I happen to see it the other way. Okay. Let me see if there's any questions specifically on that I need to get to. She's not wrong. She just can't explain it like a human. Well, that's a problem too, obviously. And I'm not saying I'm not misunderstanding it, right? I could be misunderstanding it. That's the Commonwealth job. And I take that burden as a plaintiff's lawyer. If the jury's confused and they don't understand how something happens, that's on me. That's like my job, right? They had to change the camera because of something that happened in the beginning. I kind of explained it in the beginning of this video. But okay, so the next kind of part of her expertise and her opinion was, why does it look like some of this stuff was deleted? She said that's a very common mistake people make. So let's hear her explanation of how it actually wasn't deleted.
Now, as far as that sort of interplay between the SQLite database and the wall, what if any sort of, as a forensic examiner, what if any sort of complexities arise out of it?
Oh, one of the biggest complexities is the assumption that because data exists in the write-ahead log, that a user took an action to delete it. When I teach at the university, when I peer review my colleagues' reports, this is one of the most common mistakes I see. And it's really because some of the forensics tools to indicate that the file has been recovered, they put a big X on it. And that was actually a big subject of that standardization of file recovery paper I referenced earlier. And it speaks about all kinds of files, but actually has a special section on SQLite, specifically because that nuance is often missed by examiners.
Now, in reference to that being marked as deleted or misinterpreted as deleted by a user, is there a specific tool of the tools that you mentioned before, as far as SQLite versus Axiom versus that has that information that others may not?
So SQLite and Magnet Axiom, both SQLite Physical Analyzer and Magnet Axiom, both have file system viewers that then have SQLite database viewers. I would say that those SQLite database viewers have more of a basic function in terms of looking at data in the live database. They don't allow for deep analysis of the write-ahead logs, which is why in my analysis I use the specialized Sanderson forensic browser for SQLite.
And so when you see something like that in a SQLite extraction, is there what, if any, further analysis do you do to sort of look behind?
Absolutely. Anytime I see an entry marked as recovered, and I'll use the term recovered instead of deleted, by SQLite, and the source is a write-ahead log, I would go and begin reconstruction of the write-ahead logs using Sanderson's forensics tool to get to the meat of, is this something that it has been deleted, or is this something that has yet to be written to the database? You can often see remnants of that based on how many unique entries there are of it. What the other thing we do is, so I mentioned that when we have the wall file, it hasn't been applied. So if I take the SQLite database and the wall file out, and I make another copy of them, so I've got one copy I'm looking at Sanderson, and I take another copy and I actually open it, what's cool is it does the commits. So then I have a copy of the database that actually has all those changes. So I now know if the entry was deleted by just comparing the two. So I can do that analysis by basically making the database think it was reopened, by reopening it with a non-forensics tool in that instance, just to see what it would look like in real life. And then I can look at the difference between the two and determine if something was marked for deletion or addition.
Now, are there different reasons from your training, your experience, and your knowledge of these systems? Is there different reasons for why it's your conclusion that that particular search or those search terms were not deleted by the user specifically?
Yeah, well, there's a couple of reasons. First, the way tabs work from a functional perspective, you can close a tab, but there's not really a user deletion function for the tab. And there was no evidence of other deletion, if that makes sense. It doesn't make sense that the term was, I don't see evidence that the term was searched prior to that 624 time. So since the term wasn't searched prior to that 0624 time, the existence of the tab being closed would not mean that that search was deleted, because then it would be evident in the other databases pertaining to the actual search, not the databases pertaining to the state of the tab. Is there a possibility that the tab was closed? Absolutely, but that is not a deletion. Secondly, an existence in the wall file, as we mentioned, could be that it's something new, not something that was deleted. So just its mere existence in the wall file doesn't mean it's deleted. I should say that that same X in the tools, you have to check the file because it could be from a free list or a free page, in which case, I know we didn't go into those details, nuance of SQLite databases that actually doesn't pertain to this. However, those would be truly deleted items. So there's other places where we would expect potential recovery, not necessary in this instance. And you can have something that's in a wall file and deleted without being in those other locations. Just stating that its existence in the wall file itself doesn't mean deletion. But there are other SQLite things that would clearly indicate deletion that aren't applicable to this particular search.
Okay. Don't expect the same explanation here from me. Okay. This does kind of make sense to me. I will tell you, I don't fully understand it, but I think the gist of what I got is she says there are other things you can do to double check if something was actually deleted, and she did that and it wasn't. That's, I guess, what I got, but I got to be honest, to me it was not the clearest explanation. It was not the clearest explanation, but basically she's saying it wasn't deleted. I don't know. I don't know. It's a tough follow. Okay. It's a tough follow. Then we get to her explanation of like how many times each thing was searched. One of the things I don't think defense asked on cross that I would have asked is, when was the first time Haslong to die in the cold was searched? I know he asked, like, you can't say for sure that it wasn't 127 or 227, which we'll look at, but he didn't ask, so when was it searched? And if she would have said right before 623, that search, I would have been like, then why doesn't it just say 622 or 623 like that one?
And here we have the order index, and here we have that last view time. And by looking at the last view time, which is the raw title of that artifact for the timestamp we were looking at, these are identical. This, and more importantly, are even the actual UUID for these are identical, which is right here. Now the offsets are different, and what that means is that this is just appearing several times in the write-ahead log. It has moved as the database has moved data through the write-ahead log to different positions, but has in every instance the same unique identifier, meaning that all of these entries are the same entry, just shown multiple times in the same database.
And to that point, as far as the multiple times that it's listed within there, what, if any, relationship does that have to how many times it was actually searched by you?
Well, that UID shows that in this particular instance that it existed once in the last time in the tab, because this artifact, it does not tell us how many times something was searched by the user. This artifact is limited just to the tab. We would look at the mobile Safari plist, which has one entry for this timestamp, or knowledge CDB, which also only has one entry for this search. Those two locations are where we would determine how many times it had been searched, as opposed to this location, which could tell us that if there were multiple entries, but there is only one. But since this is limited to just the last search that's showing in a tab, it isn't a good source to say how many times was it searched, just not this particular artifact.
But from other artifacts, you were able to determine that?
Absolutely. You can determine that from both mobile Safari plist and knowledge CDB.
And I'm sorry, I jumped in there just as far as turn your attention back to figure one. What, if anything else, of significance do you know in that?
That's really what's of significance, is that it is the same entry there multiple times, and we can tell by the unique identifier that it is the exact same entry also. And it's, although it's the same search term and the same timestamp, it's only one instance of it, just it's stored in the database multiple times at multiple offsets.
Now, from the timestamp associated with that depicted in this figure, what, if anything, can you say as to the, or what, if anything, were you able to conclude from your analysis as to the time that the website was viewed?
Well, I guess I should really clearly, for people who may not be familiar, that doesn't look like a normal time, right? That's because this is an Apple WebKit timestamp. So we actually...
All right, we don't need to hear her explain that. But so actually, I think she does explain when the actual website was viewed. So let's stay.
Even though you don't know what it is, but if we put it into a decoder, this particular timestamp is where we're getting January 29th, 2022 at 02:47 a.m. And to be clear, just for real clarity, when we actually translate this timestamp, it's in universal time constant, not in local time, but for the sake of conversationalists, I'm using the local time here as opposed to the time in the universal time constant, which is how this artifact is particularly stored.
Now, with your analysis, is there some kind of testing that you conduct, or can you explain to the jury sort of what that is and how it...
Maybe not, I can't remember, but she goes through a bunch of testing. We're not going to listen to all of that. I like her disposition personally. A lot of people said they didn't, and they thought she was kind of full of herself or things like that. I liked her disposition. I think she spoke a little too quickly, especially for how complex some of what she was testifying to was. But eventually they get to what the defense's opinion is and what issues she has with the defense experts. So that's what we're going to listen to now.
Using the proper algorithms to dissect that data and determine what it is based on testing and knowledge. So I think it actually influences in a positive way the depth that I go through in my analysis.
You had mentioned earlier in your testimony that you had reviewed both Trooper Garino's report as well as an affidavit from Mr. Green. Is that correct?
Correct.
And with regard to the affidavit from Mr. Green, what, if any, issues of course of significance did you observe in his affidavit?
In Mr. Green's analysis, there is a conclusion that is drawn that a search occurred at 02:47 a.m. on January 29th, based on the artifact recovered from Browser State DB that SQLite parses. And there are two errors with that. The assumption that that is the time of the search is a misunderstanding of the Browser State DB artifact, because that artifact is not the time of search, it's the time of movement of the tab, as well as the statement that that it was deleted due to the demarcation of SQLite as recovered.
And based on the totality of your analysis, your testing, and everything that you looked at in this case, what, if any, conclusions did you come to?
My conclusion is that there was a search at 02:47 a.m. for Hawk.
She says 247 a bunch of times. Obviously, I assume she means 227. It's not unusual for the Commonwealth to be off a little bit on some of that stuff, but I think she means 227.
Mock Sports, and that browser was in use, and there were continual searches due through the night. The phone was, I do agree with Mr. Green's findings that the phone was in use at that time at 02:27. Later, the phone a web search is done at 6:23 a.m. For how long, at that moment, Apple produces a suggestion for how long to digest food. The search is instead completed with how long TI, die, and CKLD at 6:23. A new search is conducted at 6:24 of HOS, long to die and cold, HOS, long to die and cold. That search is then the last search that is made in that particular tab. And that's my conclusion.
What, if any, conclusion?
All right. Well, hold on. Let's see if I think she's got another conclusion.
Did you come to in regard to items being deleted pertaining to those artifacts you were looking for?
In regards to those artifacts pertaining to those search terms, I had no evidence of deletion.
May I have a moment, Charlie?
Yes.
All right. So that was basically her summary of her opinion tied up in a bow. Okay. And I think it's plausible. If the jury buys it, it's good for the Commonwealth. If they don't buy it, obviously, it doesn't help them that much at all, obviously, if they don't buy it. Why no location network info on searches? And then somebody else said, I may have already put it up there, where somebody said she didn't have all of it. Gosh, I thought I held it for this, but so she didn't have all the evidence to do a full forensic download of the phone. She was just asked to do a couple very specific things. RS said, are we to believe law enforcement can't find time to Google search in 2022 after a full phone extraction? If 227 is a tab open, what is the real search time? That's definitely a big question. Azam said, so does this mean 227 search didn't click enter, only registered the spot search, the sport search, and then 624 they click enter? Yeah, I'm confused. I don't know. She didn't say that, so I don't want to say what happened because I don't know, obviously. Sandy, if a juror doesn't understand what she is saying, can they speak up, or do they just hope another juror understands? I mean, usually if a juror doesn't understand what a witness is saying, it's not going to come into their analysis when they make a vote for guilty or not guilty. That's usually what happens in my experience. Lauren, Peter, when are you going to tell us you are on the defense's payroll? Every video hyper-focused on your problems with the state's evidence. It's very clear where you stand on this case already. So let me tell you where I stand, because I feel like I have been clear where I stand the whole time. So I'm not on anybody's payroll, except for my own here at the law firm. But this case, like every case, starts with the defendant presumed innocent, cloaked in the presumption of innocence. So I would vote not guilty at the beginning of every single criminal case. I don't care if I know what evidence is coming and there's a video of them committing the crime. My vote is not guilty until the state puts that information and video into evidence. Okay. And then I remain on the not guilty side and the presumption of innocence side until and unless the state proves their guilt beyond and to the exclusion of every single reasonable doubt. The Commonwealth in this case has come nowhere near doing that, in my opinion. Nowhere near. They've proven with this witness that possibly Jen McCabe did not make that Google search at 227. Sure, it's possible. I don't even know if they proved that beyond a reasonable doubt, but to me, that's still not proving their case. So I have been accused seriously by the free Karen Reed people that I'm ignoring the obvious, that this is a cover-up, setup, whatever. I don't feel like I'm ignoring the obvious. I don't feel like that's been proven either. Good news for the defense. They don't have to prove it. What they have shown is how horrible this investigation has been. and how shoddy it's been and how there's conflict of interest all over the place. And it makes it really hard to find this investigation to be credible and to be done with integrity, no matter how many times the troopers tell me that's how it was done. That's where I stand. I feel like I've been there the whole time, but I'm still open to them. This state's case is still open. I'm still open to them being able to prove it beyond reasonable doubt with certain evidence that maybe started today. So we'll see, but that is where I am at this point. I don't feel like I've tried to hide that. And Rebecca follows it up with, Peter, please do not allow people to make you feel unbiased. Us that you know, better remember your opinions. A-holes like everyone has one. Yeah, I think what this is kind of to encourage me to not worry about that. And I really don't, because I look at this stuff and I tell you guys exactly how I see it. And just so you know, in every case, people disagree with me. There are people that disagree with me in every case. Okay, so let's get to Cross now. And again, all the other side was saying, oh, why does he need to be careful? Yeah, right. They're not going to be careful, whatever. It's like, I wasn't saying he needs to be careful as a slight to the defense. I'm saying I would be careful too with a witness like this.
Good afternoon, sir.
Ms. Hyde, you just spent maybe 45 minutes to an hour, whatever the time period was, explaining to these jurors what is really a complex set of facts that led you to conclude the 2:27 a.m. timestamp on that Google search was...
She is so close to that mic that is her breathing into the mic, so nothing we can do about it.
Triggered by the closing of a tab. Did I essentially sum that up correctly?
Essentially, except it's not a 2:27 a.m. timestamp on a Google search. It's a 2:27 a.m. timestamp on a tab.
Fair enough. Thank you. And in the context or in the course of your explanation, you discussed WAL files,
That is correct.
SQLite database,
Yes.
PLIST database,
Yes.
knowledge seed database.
Yeah. PLIST is not a database. Just it's a structure. So just a small correction.
Thank you for the correction. Opening tabs and closing tabs, correct?
Yes.
And other issues related to your analysis of the phone extraction, correct?
Would you call them issues? Or
Well, maybe that's a bad word to use. Other elements.
that's fair enough. Yes. Yes.
I'm really not trying to trick you. I know I wouldn't be able to.
I'm really not trying to trick you. I know I wouldn't be able to. Did they say that to Trooper Proctor? Did they say that to some of the other people that they've really hammered? No. I know they've called some of the cops, you're educated, right? You should know this. I mean, they're almost baiting people with some of that sarcasm. In my opinion, that wasn't sarcastic. That's respect, and I get it. This lady knows more about it than Yannetti, Jackson, myself, any lawyer. And also another thing, just, about Twitter and people talking about this, I think it's cool. I like hearing from experts. I like knowing what, forensic experts and computer guys all say about how this works and all that. And that's cool on Twitter. But we got to remember, regardless of what my experts that I use in my cases, what people on Twitter are saying, on YouTube, whatever it may be, this jury is listening to these experts. So that's how we have to analyze it. And maybe there's a computer expert on this jury. Maybe there's not. But if there's not, they're not going to necessarily know all the stuff other people are talking about around the world with this case. We got to remember that as well.
Would you agree with me that another simple explanation for that 2:27 a.m. timestamp was that the user of that iPhone conducted that search at or before 2:27 a.m.?
Can you rephrase, please?
I'm going to phrase it the same way.
Repeat it, please.
Thank you. Would you agree with me that another simple explanation for that 2:27 a.m. timestamp was that the user of that iPhone conducted that search at or before 2:27 a.m. on January 29th of 2022?
That timestamp is not indicative of a time of search. So the question is difficult to answer because I can't say that timestamp tells me anything about the time of search.
Okay. So
it just seems crazy to me. I'm just going to be honest. Like, if I'm sitting there as a juror, I'm like, if the defense expert just got up and said, and he's from all these places with all these expertise, and he put it through all these databases, and he's like, that's exactly the point of the timestamp, is to tell us when it searches. I feel like I'd be like, I got to go with that because it just makes more sense. I like this lady. I think she seems really smart. That just doesn't make sense to me. That just seems like an inaccurate report. Why report that timestamp then? Why not just report it as tab opened and have the timestamp actually report when you typed in? They've got to be able to do that with technology.
Your as I take your answer,
Mhm.
you're not denying that the timestamp and whatever you get from that timestamp doesn't rule out that the Google search was done at or before 2:27 a.m., correct?
If I'm understanding your question, there was a double negative, so I just want to clarify. The question is if the timestamp could exist because of a search happening at that time?
No.
Or, no, okay.
What I'm saying is your analysis of the phone does not rule out that the user of that phone performed that Google search at or before 2:27 a.m.
There is no indication of a Google search at or before 2:27 a.m.
But again, I'm getting to whether you can rule that out, ma'am. That's really the crux of my
I
question.
thought the basketball one was at or before 2:27. Or maybe it was like, I thought that's what she said. I don't know.
Can you rule out that the user of that phone conducted that search at or before 2:27 a.m. on January 29th?
There is a very unlikely possibility based on the fact that there is no evidence that the search occurred before that time. That's just like saying,
So he wants to say, is it possible? And she says there's an unlikely possibility. And he said, and then she answers with this, which again, she lost a little credibility with this example to me. And I'll tell you why after.
that the user searched based on the fact that there is no evidence that the search occurred before that time. That's just like saying that the user searched for pandas at 2:27 a.m. Could you rule that out? I can't rule out something that's
It's not the same though, ma'am, because Hasselong to die in the cold was actually on the report. Searching about pandas was not on the report. If she would have just stopped after there was no evidence the search was actually made, I would have been like, okay, that's consistent with the rest of your testimony. Didn't love the extra steps she took there.
doesn't exist.
Well, you would agree with me that with regard to your analysis of this phone extraction,
Mhm.
you were given very specific instructions in terms of what to look at, correct?
Correct. I had a very limited scope in this analysis.
And who was it that gave you that limited scope?
That scope was relayed to me by Detective Tully.
Oh. And Detective Tully instructed you specifically to only look at the part of the phone extraction that dealt with the Safari search history. correct?
Safari search history specific to January 29th, 2022. That is correct.
And he instructed you not to look at anything else on the phone, correct?
I looked at related artifacts such as what was being done at that time, the phone being on, the phone being used, but not anything else outside of that, correct?
And you were not instructed, for instance, to look at other user activity on the phone, including examining call logs on the phone, correct?
Correct.
And you would agree with me that if you were allowed or instructed to examine the call logs, that could reveal deletion of calls that morning, correct?
Of
Objection.
course. Well,
Okay, the objection is sustained.
Thank you.
Any follow-up, Mr. Lally?
No, Your Honor, no redirect.
She's like surprised. She's like, oh, that's it. And again, it was pretty quick. It was short and sweet. It was in and out. He did what he needed to do. She didn't look at the other phones, the other deletions, the butt dials, anything like that. No opinion on all that stuff. So she's done. Rebecca said, I disagree with you often, Peter. Yeah, privately and publicly sometimes, right, Rebecca? Wafa said, Peter, it's sad that every Commonwealth witness gets trolled. Don't you think it's wrong? Of course. The abuse every witness gets is terrible. Can't wait for the BK trial. I mean, I hope you're not, I don't think you're saying I'm doing that. I'm not abusing her at all. I feel like I've complimented her a ton. I disagree with her on certain things. I don't even disagree with her. It's hard for me to believe with certain common sense, some of the things that she's saying. I would never make fun of somebody's appearance. I think it's inappropriate when people do that. I don't see the reason for it. It has nothing to do with the trial. And that's what I try to focus on. So hopefully you're not assessing that at me, and I don't think you are. Richard, hey, Peter, loving your show. My beautiful girlfriend introduced me to you. Please give her a shout out for me and tell her I love her. Well, Richard just seems to love you very much. Richard's gal. Okay, so then we're going to get into the next witness, Trooper Joseph Paul. And I was like, is this the accident reconstructionist? Yay. And we're going to start out by just kind of showing the map that he created. And he talks about where he plotted all the points and why he plotted these points. And as you can see, pedestrian's final rest, glass cup, flag, shoe, plastic pieces, glass, fire hydrant. You know what's not there? And he confirmed it. All the pieces of plastic they found. And why is it not there? Because they didn't bother to plot them all on the GPS. Which again, that's how this lack of credibility builds and builds and builds. When you screw up something that seems like it's small, maybe it would have been important to this. If it would have shattered and kind of gone everywhere, would that have told us the impact was even higher or harder? Right? So they may have missed out on even proving their case more with the bad investigation and record keeping and documentation. So then we get a picture of the SUV coming in, very clear. And he says this is what it looked like on February 1st, I believe. So, oh, by the way, yeah, he used all the tools and drones and all this stuff to map it out and GPS it, so it all made sense, of course. So I don't want to just gloss over that, but he did lay all the foundation that you need to. Let's get to 355. So he said this is how it looked on February 1st.
That's a crime scene photo that I attached to my report with notations that I made on it.
And what's contained in this photograph is that a fair and accurate portrayal of what you observed in the rear passenger side area of the defendant's vehicle in the garage on February 1st.
Yes, it is.
Now, step back a little bit here. With regards to what you've noted within this, if you could, using the laser pointer before you, just direct the jury's attention to what, if anything, of significance you observed in your inspection of this area of the Lexus.
Okay. So on the left side here, I put down the scratches, and there's a dent there. The broken taillight here was here. There's some scratches on the bottom right rear bumper here. And there was glass from a cut back on the bumper.
As far as the
Glass from the cup on the bumper, which I think is interesting. Like, how does he know that? How does he know that?
glass on the bumper, what, if any, observations did you make of that in relation to the vehicle itself?
Yeah, it appeared to be from it.
I do think that this scratch and dent here at the, I don't know, middle or left side of the screen, I do think that's good for the Commonwealth. Like, that makes more sense hitting a body than a car. I think that's good.
A cup as opposed to any glass that came from the vehicle.
Objection.
So I'll strike the first part of the answer, but the second part will stay.
I have no objection to the second part. Thank you.
Now, with regard to the dents that you've delineated within this photograph, did you take any measurements from the ground as to where that was located?
Yes, I did.
And how far did you measure the dent to be approximately from the ground?
Approximately 48 to 50 inches from the ground.
And what many measurements did you take as far as from one part of the vehicle to the other, as far as where the dents were located?
Yeah, so it was approximately 19 inches from the right side of the vehicle.
Now, the scratches that you were talking about before, where were they in relation to the dent?
Right above the dent. I see right there. That's my hand shaky.
Now, as far as you obviously also made observations of the driver's side taillight as well.
Yes.
And so, from what you observed with the driver's side taillight versus the passenger side taillight, what, if any, observations did you make as far as the color of the pieces that you found missing from the passenger side taillight?
As a compared,
Lally's questions like make me laugh. Like, what's the difference between when you're looking at the left taillight and the right taillight? It's like, well, it's missing pieces.
just into the left side of the taillight.
Yes.
So on the left side of the taillight, there was red and clear plastic pieces.
Now, the scratch marks along the bump, did you take any measurements with relation to them?
Yes.
And specifically, did you take measurements from the ground to where they were located?
Yes.
What did you measure those?
They were approximately 27 to 28 inches from the ground.
The measurements are important, right? 27, 28 inches from the ground. He measured that. We know that. Now let's see how that's used as we reconstruct how this matches up with John O'Keefe's injuries. That's really what I've been waiting for.
Thanks. So we need to take that down.
All right, we're going to jump ahead a little bit. He talks about how they tested the mechanical stuff, brakes, steering, whatever, no mechanical issues. I think he said it was 7,000 pounds. Talks about reverse speed testing, all the different testing that they did, brake testing, decel testing, no issues. Explains linear momentum. They got data from her SUV. So this wasn't great. And again, I'm not trying to nitpick, but I feel like I got to point out what I found to be important while I'm listening. I would not love it if my expert, if this was true, that's fine. I don't feel like I would have needed my expert to say this.
Police Department garage.
That's correct.
And so, as far as the timing of that being February 2nd of 2023, why was that?
I was at the time of my initial inspection. I didn't really know much about tech stream at that point. So over time, I kind of learned about tech stream, and so once I learned about it, and I thought this is relevant to our case, and I looked more into it and found that it is relevant. So.
And the Toyota tech stream, as far as that applicability or that.
I'd rather you just skip that part. You know, if the defense brings it up, fine, but like, don't tell the whole jury that you didn't really know anything about this tech stuff that you got out of the Toyota/Lexus. Just again, a small little nitpick there, which people can hit me for. That's fine. He explains the key cycle, explains when she was kind of going forward, backward. I think how it would have been a turn. It was indicating a turn that they've talked about a little bit before, which was the first triggering event. But the big one, the collision, is the second triggering event. This is the big section of the testimony we're going to focus on here with this witness. And just so you know, when I do these videos, like it's already almost an hour, I would love for them to be an hour. I try to make them an hour. It obviously means I can't hit everything I want. I can't hit every single thing in the video, which always sucks. So I'm always going to miss stuff. I try to pick out the interesting stuff to me.
And how far into this 10-second data set was the vehicle placed into reverse?
At 4 seconds, it's right here.
And so am I correct then that there is a 5-second difference between 4 seconds when it's placed in reverse and 9 seconds approximately when it achieves that 24.2 miles per hour?
Correct.
Now, as far as the 74.5% pressure that's placed on the accelerator pedal, when is that recorded in seconds in relation to the 10-second data set in this data?
74.5 starts at the 8 seconds.
Now, as far as this trigger is concerned, I understand from your testimony that the maximum speed is 24.2. Is that correct?
Correct.
And what is the vehicle speed recorded at the end of this 10-second data?
23.6.
Now, as far as the vehicle being in sort of different sets, as far as drive, reverse, things of that nature, what, if anything, did you observe within this data set as far as how it is at the beginning, how it changes at all? What happens with regard to that in the data set?
So this one shows that the vehicle was in drive. It starts off in drive. It's slowing down to 0, and it goes to 0, which is neutral, then goes down, then it goes into reverse. So it's going straight, it stops, then it's placed in reverse, and then goes back, goes in reverse.
Now, as far as the reverse is concerned, you indicated there's also some steering angles that are recorded with this data.
Yes.
And what, if anything, was recorded in this 10 seconds of data? Specifically, I'm asking from the time that it goes to reverse to the end of the set, the end of the data set. What, if anything, do you observe with reference to the change in steering angle of the steering wheel?
It does not change much. It's only 13. I think the far it goes is left is at 13.5%. So that's only, I mean, if the steering wheel's a circle, the whole circle's 360 degrees. So 13.5% is only, and it's still fairly straight in the vehicle at 13.5%.
So from this data, this vehicle is backing up in the manner of about 5 seconds or so, in a fairly straight line, and achieves a maximum speed of 24.2 miles per hour, correct?
Correct.
And even at the end of this data set, the vehicle is still traveling approximately 23.6 miles per hour.
Correct.
Now, as far as the small deviations in the steering that you were testifying about, based on your training and experience, what, if anything, would cause that?
Well, the steering wheel was obviously caused by operator traveling only small amounts, right, and up to here. So it's only just operator steering at those small deviations.
Your Honor, may I approach?
Yes.
Grab that one.
Closer up snippet of that document that I have attached to my report.
And Your Honor, may I approach?
Yes.
Hard practice. How will you introduce this next exhibit? Objection.
You can go ahead and, you can go ahead and publish it if you're inclined.
Trooper Paul, once we get it up on the screen as this next exhibit, if you could use the laser pointer just to direct the jury's attention to what, if anything, of significance you observe in this portion of the data.
Yeah, so I circled in here if they drop from 24.2 to 23.6, and also the steering wheel signal went from a left at 4.5 to a right 4.5, so positive to a negative. And also the same thing with the accelerator opening ratio kind of stays consistently 74%.
May I approach again, Your Honor?
Yes.
Attach my calculator and attach to my report.
And may I approach again, Your Honor?
Yes.
I'll proceed to introduce the next exhibit. Paul, do you recognize what's up on the screen? It is now been marked as exhibit 596.
I do.
And again, if you could use the laser pointer, let me ask you this first. As far as this table and this information up on the screen, I should have asked this before. How was this table created, and what, if anything, does this illustrate?
Yeah, so this illustrates from the chart of 12,609B. I started from when the vehicle was placed into reverse, and when it immediately goes from 0 and travels up to 23.6. Just that's like the last part of that last chart we had.
And what, if anything, were you able to do as far as distance travel, and how were you able to determine that?
So I used the vehicle speeds and the time, and calculated a distance that the vehicle traveled during this time.
And as far as the total distance traveled from the 0 to the 23.6 at the end, what was the total distance there?
97.35 feet.
And with respect to the vehicle's maximum speed, as far as 24.2 miles per hour that's recorded within this data set, how much distance had the vehicle traveled prior to achieving that 24.2 miles per hour?
62.51 feet.
Thanks. May I approach this retreat?
24 miles an hour, traveling 62 feet. Okay, that's basically what we're learning here. When in reverse, punch the gas, 24 miles an hour top speed, 60 feet.
Here you go.
Yes.
Now, Paul, with regard to, based on your training and experience, with respect to this type of data and crash reconstruction in general, this particular set of data from, who's the name again? From 12,629 miles B, what, if any, type of collision is that data set consistent with, and why?
Yeah, there's a point there where it appears to be consistent with a pedestrian strike.
And why is it that your interpretation of that data you feel is consistent with the pedestrian strike?
It's the sudden change of speed at 24.2 to 23.6 in a half second, while the accelerator pedal is still at a consistent 74%. And also the steering wheel angle goes left to 4.5 degrees and also goes right to 4.5 degrees and then goes back to left after that. So
what he's saying is right when it goes from 24 to 23, that's indicative of hitting a person. It doesn't go from 24 to nothing. It's indicative of hitting something that is not immovable versus the size of the car.
right at that spot, something that's consistent with a pedestrian strike.
Now, with respect to Mr. O'Keefe, the pedestrian in this collision, what, if any, data were you able to see or review in relation to your reconstruction analysis in this case?
So here's something I want to point out. Chris said, ding in the back of the car and the glass on the bumper. Maybe they fought and he threw the glass at the back of the car while she was driving away. So here's what I'll say. This type of, searching is kind of like searching for a reason to explain away a fact for the Commonwealth. Okay. And I get it why people are doing it. And sometimes jurors do it. You'd be shocked. Sometimes jurors tell me like the reason they came down on one side and I'm like, what? That's what you were thinking. So it does happen. So I don't want to discount it too much. What I try to do though, instead of saying, well, this could have happened or this probably happened, that fits into the defense's, theory, I say, did the state prove to me the fact they want to prove? Forget about what fact the defense wants me to believe. Did the state prove to me that that ding or dent was caused by John O'Keefe? It could have been a million things. Literally could have been from a million different things. Same thing as this going down from 24 to 23. That could have been from hitting a curb or going from the street into the grass or something that slows you down, presents more friction, like a body or other things. So it kind of lines up that it could be a body, but I need more than that, right? We definitely need more than that. But it makes sense that it could have been from hitting a person. Rebecca said, I very rarely give medical opinion, but where are the injuries below the clavicle to pelvis or extremities? We're waiting on that 28 inches or whatever he said off the ground. That's not very high on a 6'2" male. SN said, Peter, I heard this witness say he took 2 classes with that. Was that in Reconstruction? Does this make him an expert? So usually cops that get all this experience, take a couple classes, they can be called experts. That's why I think the defense is going to take some time with their experts and their background and their expertise. I also don't know that this is the only person that's going to testify to this stuff for the Commonwealth. So we're going to wait. Just Linda said, where would the hair be? It was to the left. It was on the actual back of the car. James Carr said, can you move the CC to the top? It blocks super chats. I need to read what's going on. I will try to do that. Lauren said, oh boy, I wasn't coming at you, Peter. I don't mind disagreement. I don't. And you think if you thought I was on the payroll, said it was a joke, everybody relax. Everybody relax. I didn't know everybody's coming at you, but people have said that to me. A ton of people have said that to me, not joking, legitimately not joking. Barnett said, think she'll take the stand? At this point, I would guess no, but I don't know. I'm a recent law school grad, worked in the DA office for a year now, working in PI. That's awesome. I can see arguments for both sides. I would guess no at this point. Charlie, did they find any cucumber on that area where the glass contacted the car? Got me. Peter, you ever had a judge wearing an earring? Yes, I have, Tyler. Yes, I have. Okay, a couple people here saying anyone who's lived in the snow knows gassing your car in the snow can spin your tires, showing a higher miles per hour. Thank a Farmer said the same thing. Anything that says that didn't happen? No. So I don't know what the defense is going to say, but if they provide a more plausible or logical answer, then obviously we're going to have to consider that.
As far as Mr. O'Keefe, what, if anything, did you learn about his injuries?
Like what types of injuries he had?
Now he's going to correlate the damage, the time, the slowdown, how it's indicative of a pedestrian accident. What about O'Keefe's injuries? What are they, and what do they make you think happened?
Yes.
There were blunt force injuries. So it was abrasions or lacerations, and blunt force injuries.
And the injuries.
That can't be it. That can't be it, right? That really can't be it. It can't just be abrasions and cuts and bruises and, you know, a little bit of this, a little bit of that. He's got to have more information he connects.
That you observed or that you were informed about, that you learned this from the medical examiner, is that correct?
Correct.
And with respect to the injuries Mr. O'Keefe was reported as having sustained, according to the medical examiner, what if any relationship did those injuries have to you in relation to a pedestrian collision?
So people are asking, how can he testify to this if we haven't heard from the medical examiner? He has her report. He can consider her report. She can testify later if she's called. And I think that's, you know, what he does and how he uses it as foundation.
Say it again.
As far as the injuries that you were informed by the medical examiner that Mr. O'Keefe had sustained,
Yes.
What if any relationship did those injuries have in relation to a pedestrian collision?
They are consistent with a pedestrian collision.
And how so?
Due to, I mean, we break down each injury due to the arm, the lacerations of the arm from the tail light, the dent with the scratches for his hand. They are
So we get our first testimony. The lacerations on his arms from the broken taillight. So that is the state's position. It's not from being dragged on the asphalt or being hit and then his body tumbling and scraping up his arm on the street or anything like that, or the curb or the sidewalk or whatever, anything else, the hydrant, the fire or the flagpole or bushes. It's not what any of that's from. That's from the taillight. That's what he said. That's hard for me to buy. I got to be honest. If that's how he's going to explain it, I almost don't consider it. You got to give me more than that. You got to give me measurements. You got to say you did it on a cadaver and sure it came out just like that, because just from the naked eye, looking at those scratches on his arm does not look like it happened from a tail light that was not as long as the scratches are on his arm. I got to get more than that.
consistent with a pedestrian collision.
And how so?
Due to, I mean, we break down each injury due to the arm, the lacerations of the arm from the tail light, the dent with scratches for his hand could be. Those are something that
For his hand could be is not good enough for me beyond a reasonable doubt. Just me. I don't know about for these jurors, but I'm just talking about myself.
would be consistent with this in this particular case with striking Alexis.
Now, specifically with reference to this case, what, if any, analysis did you conduct with regard to kinematics?
Yes, I did a kinematics analysis in my report. Kinematics deals with the aspect of motion.
And I'm sorry, if you could expand upon that just a little bit and explain to the jury sort of what kinematics analysis is.
So kinematics analysis is, like I said, it deals with the aspects of motion. Pedestrian crashes get kind of labeled in certain types of how they interact. So in this particular case, I kind of labeled it as it's a forward projection crash with a side swipe. And what I mean by forward projection means that when a pedestrian gets struck by a vehicle, well, basically their principal impact forces are above the pedestrian's center of gravity, as in this case where you get the higher back of the vehicle. When you get struck by something like that, it projects you forward in the direction of the vehicle. And in this situation where you get more struck through the side of the vehicle on the taillight area, that it projects him to forward and then to the left due to this like more of a side swipe manner.
Now, with respect to you mentioned the height of the vehicle, as far as the shape of the back of the vehicle, what, if any, relationship does that have in regard to you sort of labeling this?
Okay, so we know he measured the height. So how does that height and shape of the vehicle correlate with the injuries we know John O'Keefe has?
As a forward projection / side swipe collision.
Yeah, due to being pretty flat, it's not the front of the vehicle. We have the hood, and the pedestrian staying above the hood. It's the back of the vehicle. It's pretty flat and it's pretty higher up.
This might land on the side like Sleuthy and I were talking about earlier. Maybe this is too dumbed down. Like it's kind of straight and a little bit higher up. So that's why we know these injuries line up.
Now, with respect, you also made aware through your review of the medical examiner's report that there was injury to the back of Mr. O'Keefe's head.
Yes.
And based on your training experience and particularly with pedestrian collisions, what, if any, significance did that have in relation to your opinion as to how Mr. O'Keefe interacted with the pedestrian?
So when you look at the damage, he would have interacted with that left side of the vehicle. And when he got struck by the vehicle on the left side, it would have caused his vehicle to rotate kind of counterclockwise. And then when that rotation, he could turn it into his back, and his back could have struck the ground. I noted at the scene that there was asphalt curbing, which could have somewhere he could have struck his head in there, or somewhere along any of the pavement would have caught.
Asphalt curbing. Okay, it's the first time we're hearing that. And maybe he could have struck his head there. Did you do testing? Did you go look at least? Did you see how his body would have had to move to hit the curb and end up where it did? How far away is where his body is from the curb? Those are detailed questions that are really important in situations like this.
Damage. Most
I agree.
crashes.
I have thought the street, the curb, the sidewalk, bushes, the ground, if it was hard because it was cold, all that stuff could be really good and worked in if that correlates to, where his body and his head hit. But these are just conclusions. These are conclusory statements without enough data backing it, in my opinion.
have damage on both sides of the body.
Why is that?
Due to them get projected forward, so they get hit from behind, they had damage to the back, and then when they get projected forward, they get damage to the front. So, I mean, in this case, he got projected and got spun counterclockwise due to where he got impacted the vehicle.
Now, with regard to the vehicle speeds,
He spun due to the impact with the vehicle. Did he prove that? I might be missing when he proved that.
kinematically speaking, from your analysis in respect to that, what, if anything, can you say in relation to, just in general terms, as far as a pedestrian collision is concerned, how much of that vehicle speed would a pedestrian be assuming in the context of a pedestrian collision with forward projection?
Forward projection will have almost 100% speed post impacts. And more, like I said, in this case, it's more the fact that he didn't get 100%, like his center mass didn't strike the vehicle, so he would not have been thrown 100% of the vehicle speed post impact. He would have, his right side would have sustained the vehicle speed, and that would cause him to spin out. So as opposed to a traditional forward projection, if he was right there in the middle of the vehicle, he would have projected forward, and he would have sustained, his full body would have sustained the vehicle speed.
That's better. That's better. So somebody has a question that's really good. I'm going to wait just about a couple more minutes for him to finish this part of his testimony. And then I'm going to tell you kind of what I would have liked to see and some things that we've done in trials in the past that I think is more effective. Some judges allow it, some don't. I don't know if this judge didn't allow it, but I am going to give you kind of what I'm looking for with these kinds of experts.
Is that abnormal as far as the sort of forward projection type of pedestrian collision? What I'm going to ask is specifically to not having any contact with sort of the bottom of the vehicle or being run over or something like that. Can you expound upon that a little?
Yeah, due to the side swipe amount that projected him off to the left, it wouldn't show that he would have been, the car would have ran over him and traveled over him. Like traditional.
Yeah,
the car would,
I'm going to ask you to slow down just a
Sorry.
little bit.
Sorry. Yes, so due to the situation in this scene where he got projected to the left and body rotated, it would have rotated away from the vehicle and his body would not have traveled under the vehicle.
Which we know because they swabbed underneath the vehicle and no go.
If you do like most, a lot of traditional forward projection crashes, the vehicle would get projected forward ahead of the vehicle, and that vehicle could possibly travel over that pedestrian.
So that is not what you found in this particular pedestrian collision, correct?
Correct.
I know you mentioned it a couple of times, but if I could ask you to just expound a little bit when you're talking about center of mass and how that relates between sort of a pedestrian and a vehicle in a pedestrian type collision.
So pedestrians, almost every object has a center mass. Pedestrians is the same. So a pedestrian center mass is essentially obviously the half the body, and you would also put down is around the chest area, just below the chest area would be the center mass for a pedestrian, and they all range based on height and body shape.
And so where on someone's body typically would a center of mass be located?
Usually just around the chest area, just below the chest area.
Now, if I could turn your attention, Trooper Paul, back to February 1st of 2022, when you were at the Canton Police Department, you mentioned that, or testified earlier at some point that you went outside to an asphalt roadway surface and conducted some forward acceleration and rear acceleration braking tests, correct?
Correct.
Now, in addition to that, what, if any, other testing did you do with respect to that vehicle on that particular date in that location?
We checked the cameras, and in the back we did backup visibility analysis with the cameras and the vehicle.
And again, if you could, just in general terms, first just describe for the jury when you say visibility analysis, typically speaking, what are you doing in a visibility analysis?
In the visibility analysis, we are trying to see what an operator would see in a vehicle. Looking for, in this particular case, we're trying to see if the operating vehicle would be able to see a pedestrian behind the vehicle. And also in this, where we have backup cameras, we're trying to look at the cameras and see what would the cameras pick up as we would go into reverse.
And in fairness to the defendant, at this particular time when this visibility analysis was conducted, it was during the daytime, is that correct?
That's correct.
Your understanding of the crash is that it occurred at night, correct?
Correct.
Now, as far as a visibility analysis, typically, would you be looking to recreate as close as you can to the conditions at the time the collision occurred?
In most typical cases, yes.
And why were you not able? Were you able to do that in this case?
We were not.
Why?
Due to it was mostly, like I said, it's mostly done when we're trying to see what a pedestrian, an operator would see a pedestrian. It's mostly done because it's an accident, but not times when it's like an intentional act. Visibility is not an issue in this situation. We were just want to make sure that the cameras worked and then backup sensors all worked in the vehicle.
So he says, if it was an accident, we'd want to see if there's visibility issue. What he means was there a bush to where she couldn't have seen John O'Keefe. And so if she was backing up and hit that bush, it would be an accident, but they already know it wasn't an accident here. Now that's interesting. If we talk about lesser includeds, I might, as the defense, be like, he said they know it wasn't an accident. I don't know. But okay. So I see some more comments coming in. Let me take a second here. I'm starving. What time is it? It's almost 7 o'clock. All right. We got to get done soon. So the issue I have, and I know Ashley said this, so we'll kind of start with her and work our way through a bunch of comments and questions about, where is it? Yeah. You buying what Trooper Paul is selling. So I think he's a pretty weak accident reconstructionist so far, and I'll tell you why. And maybe the judge tied his hands. Maybe it's the prosecutor's fault. I don't know, but I like a lot more numbers and data. I like a chart with John O'Keefe's body, 6'2", 200 and whatever pounds, standing next to the Lexus, a plot point where the scratch is, where at least some damage is done to him. It's not going to be perfect, and his body can crumple. And if his body crumpled when he's hit, you can explain how the body crumples when they hit. So, his head is not at 6'2", it's at 5'6" or whatever. Okay. And you can explain that, but you need to explain it and how there's a range of where it could go depending on where the body crumples when it hits. Okay. That's number one. Number two, I like computer generated explanations. Sometimes judges allow it. Sometimes they don't. You make it with a white block, not, a person that looks like a person, no blood, obviously, nothing like that. You show how the light scrapes across the arm, if that's your story, and you explain that. Okay. And if they don't let you do that, I do want to show he did this 30 mark. He did this testing, and I'm just going to turn off the sound so we can watch it. It's on 1.5 speed, but it doesn't really matter if it's to scale. So he did testing like this. What I would have liked to see done is put a dummy, a crash dummy, or a, blob of whatever that's a punching bag or whatever that's 6'2", 200 pounds, ram that Lexus into it, or not that Lexus, obviously, but a different Lexus, ram it into it, do destructive testing if you have to. Show me how the taillight explodes. So when the defense gets up there and says, there's no way, when all these people are telling me in my chat, there's no way that type of plastic explodes like that and shatters. If they show me with the Lexus, I'm going to believe it. I don't care what any expert says. What else can you show with a crash dummy or some kind of dummy? Go back to 34 Fairview, put him on the side of the road where you think it happened, back up and hit, and show how his body could hit the curb with his head and go, even if you need to do it multiple times, because we all agree body doesn't move the same way every time. But it's got to be physiologically possible for the body to be hit by a car and either hit the curb or the street or get dragged or whatever to get these injuries like you can have. That's what good accident reconstructionists do, and that's what I'm hoping to see. This might not be the only guy. He's not done with his testimony yet. I'm not going to write him off just yet. But it is way too vague and conclusory for me at this point for what I was hoping for to see if the Commonwealth was going to prove this up. KN said, with his training experience, where's the computer simulation? I agree with you, but some judges don't allow that. How would he test a totaled car? So you would just get the same make and model of the car. That's if it was totaled, you get that. You explain to the jury how it's the same thing, and that's what you use to test it. His test is forced. I don't even know what his test really proves, right? I think they were trying to prove with the backup camera and the beeping and all the stuff that it was intentional. She didn't accidentally hit him. She would have seen him in the backup camera. She would have heard the beeps. She still did it. That's what I think he was going with when he went through all that. People are asking about, wasn't it swabbed? Wouldn't there be taillight in his scratches? I haven't heard any testimony that there's been any taillight debris in his scratches or anything that they swabbed. Here, Lady Lysandra, why did he choose not to use an actual car and crash test dummy for the reconstruction? How might this decision affect the accuracy and reliability of his conclusion? If yes, I want to see. And I think it would have been locked and loaded. The jury would have been like, yeah, that's credible. It makes sense. It can be done at the crime scene. It doesn't always have to be. I think it would have helped in this case if they would have done some there. All right. The next part, we're going to jump to, so then he starts talking about the Ring camera video at John O'Keefe's car to talk about whether or not, or at his house, to whether or not she backed into him and if that's where she could have cracked the taillight. Objection, sidebar. We figure out why. We're going to get to that voir dire here in a second. But them moving on to that Ring doorbell camera makes me think he's done with this testimony, which I was hoping not. Danny said, love your channel, unrelated to Karen Reed. Have you been following the Feeding Our Future trial in Minnesota? Love to hear your thoughts. I have not at all. Can the Commonwealth recall witnesses to counter defense expert if not calling their rebuttal witnesses ahead of the thing being rebutted? Seems like a bad idea. Yes, they can recall them in rebuttal. How do experts always come contradictory conclusions in the case? Should we assume no one's an expert or each side is paying them to find a way their take? Who can we trust? I hate that. I agree with you. I hate it. It pissed me off in my cases. I ask my spine surgeons that. I'm like, how is it that you can say the exact opposite thing as them? And of course they say they're hired experts. We're treaters. the person came to us to help them. And I get it, but it is really, really frustrating. Genji, does the Commonwealth have means to hire jury consultants? Yes, they do in some cases. I started listening to trials when my job went remote in 2020. Court sounds like an office. Hashtag ADD. I find Lally's cadence truly unlistenable. Kathy, if what she is saying is true, what does it mean for all the policemen convicted of similar evidence? Could be problematic, right? It's not like they're going to reopen stuff, but in the future, it could be problematic. Per the judge last week, prosecutor should be done today. 60 plus witnesses, no cause of death yet. So I heard Tuesday, and now that we had this break early today, and we know that voir dire, I believe, of the defense expert is going to happen Tuesday, maybe that'll push till Thursday. I don't know. All right, so let's get into the voir dire of this witness and figure out what exactly the state wants him to testify to. So this is done outside the presence of the jury, and this is getting at what the Commonwealth wants him to testify to, what may or may not be new opinions. Whoops, got to turn the volume back on.
Of vehicles in a collision sequence and what kind of damage you would anticipate.
So obviously, the higher the speed, the more damage. The lower speed, the less damage.
Duh.
And what, if any, from the observation that you made in that video and the observations that
Usually my experts come up with like force analysis, like how much force is needed to create this damage, how much force is needed to bend the metal frame in the car. It might not look any damage on the outside, but the frame is bent. To bend that frame is more force to do that than it is to herniate a disc or fracture a bone or whatever it may be. I didn't hear a lot of that today.
you made of the defendant's vehicle. What you observed in the video, was that consistent with the damage that you observed to the defendant's vehicle?
Objection. So I'm going to allow this for voir dire. I just need to hear this information.
Understood.
It's not consistent with the tail light in this collision.
And why not?
For one thing, the collision, the tail light is, let's say, 42 to 50 inches off the ground. So that vehicle would have to have damage 42 to 50 inches off the ground, because they would have to contact each other in the same distance from the ground, and there's no damage to that vehicle. So if the tail light breaks, it should leave some sort of scratching, maybe a dent, something on some sort of damage to that vehicle should have occurred.
So I've had cases where one car is completely destroyed, smashed in, and you can't see any damage on the other car because it hits a hitch or something under it or whatever, and vice versa. I've seen it where the back of one car is smashed up, the front doesn't look that bad. Tail light's always leaving a scratch. I don't know about that. I don't know.
And with respect to, I think you just answered it. So as far as Mr. O'Keefe's vehicle, what kind of damage would you expect from an impact significant enough to break the plastic on the tail light of the defense vehicle?
That would be probably higher speed than what we saw.
For purposes of voir dire, I need to hear all of this. Go ahead.
A higher speed than what we probably would saw in there. If it's not, it was minimal, maybe it would crack a tail light or something like that, but it wouldn't. I mean, the damage is different.
So different speeds cause different damages. Yeah, okay, duh. Well, what did you see? Well, it would have had to be a higher speed than that. Well, what speed? What speed would be enough to cause that crack? What speed would be high enough to cause a crack and not cause damage to the other vehicle? Because there's got to be a speed.
Also, we have a bumper that's also in the way too.
And to that
He's
point,
asking questions like he doesn't know the answer to it. If you're going to give this opinion, you should know all these answers.
when it comes to a bumper, from a functional standpoint, what is a bumper and what does it do with respect to a vehicle and a collision sequence?
The bumper is, it's basically meant as another cushion to absorb the impact to another vehicle, from one vehicle to another vehicle. It kind of sticks out to kind of also preserve whatever, tail lights and everything else and damage on top of it.
So in order, from your experience as far as responding and investigating collisions, specifically collisions between motor vehicles, the speed that you observed the defendant's vehicle traveling in that video, what, if any, relationship does that have specifically as also as the bumper, as to the damage that you observed to the defendant's vehicle?
So if you look at the defense vehicle, there is a scratch mark that is along the left side starts from her bumper around the rear. That could be consistently with his bumper. That would be around the same height level. He has a little ridge there on his bumper. So that bumper could have been hit that little ridge. And also the bumper in itself in here is a different material. Hers is a little lighter, like a glossy colored paint. This is more a duller flat finish. So it might have some white would show up on her bumper more than it would show up on his bumper.
And finally, sir, in your opinion, the damage to the defendant's taillight is that something that could have occurred or could have been caused by the crash or the contact of the vehicles that you observed in that video? Objection.
No.
So again, this is why Mr. Jackson going in here.
No.
And again, sir, why not?
For one thing, the bumpers, you have to go push through the bumpers in order to hit the taillight against the other vehicle. And there's no damage to that, significant damage to a bumper in order to push back into the car.
And again, there was no snow on the vehicle. By that I mean Mr. O'Keefe's vehicle that even came off the vehicle that you observed during the course of that contact between the two vehicles.
That's correct.
During the course of that contact, which is interesting that he said that there was actually contact there. All right, we're going to jump to cross now.
They could have done that, right?
The tail light. We're talking about the tail light.
Yeah.
Are we talking about the tail light? We're talking about the bumper.
Yeah, we were talking about the tail light.
So one person at a time, you both are talking over each other.
You started talking about the bumpers.
Yes.
You said, well, one has matte finish and one has glossy finish, right?
Yes.
You said, well, you'd expect one of them to like slide off of each other, and they could have done this and they could have done that, right?
Not slide off each other.
You were suggesting that the two cars wouldn't match up such that the taillight could make contact with any part of the traverse. That's what you were suggesting.
I'm saying it didn't match up because there's no damage to the traverse.
You didn't test whether or not.
That's not what didn't match up means, right? I'm saying they didn't match up. So he basically, I may have missed the question where Jackson was like, you didn't actually put the cars back together and reconstruct this, even though you could have because you had both cars, right? You had access to both cars. You didn't do that. So you're saying the taillight couldn't match up. He's like, well, I'm saying it couldn't match up because there was no damage. It's like, what? There could be no damage because there was no impact, right? Could have just been no impact. That's why there was no damage. It doesn't mean that the taillight doesn't line up. I'm confused by that.
The lens, the right rear lens on the SUV could match up to any part of the traverse, right? And make contact, physical contact with it, right?
When I see a picture of the traverse,
No.
when I see the
No,
picture of the
this is a
traverse,
voir dire. I need the information,
you're
Mr.
asking me a
Jackson.
question.
Yeah,
I said,
yes or no question, Trooper.
I don't think so, but
Mr. Jackson, just for, there's no jury here. Just want to give me the information.
we did not.
Did you or did you not ever do a test where you put the two cars together and measured them?
No.
Did you ever measure the taillight of
That's
the
crazy. Like, that's crazy, dude. This is your job. It's what you get paid to do. It seems interesting, right? If you do this, like, this seems like a cool part. Why would you not do that comparison?
SUV, the black SUV, against any area on that traverse?
No.
Did you ever do any force multiplier tests to determine the forces necessary to crack the SUV's convex taillight?
No.
Did you ever do any testing to determine whether or not a plastic taillight, under how much pressure a plastic taillight would need to be subjected before it would crack?
No.
Did you ever do any testing to determine whether or not if a plastic taillight came in contact with a metallic portion of another SUV, whether it would leave any mark?
I haven't done any tests, and I've seen crashes where headlights have struck other vehicles. That's kind of where experience comes from.
Fair enough. But I'm guessing that those crashes are probably different speeds and higher speeds. Not this, right?
I've had multiple crashes at different speeds.
So have you ever
Oh,
had a
yes.
crash where you've investigated, the Massachusetts State Police has been brought in to investigate a crash where the car was going in reverse at about half a mile an hour?
Half a mile an hour?
Jackson's basically saying, you don't have any expertise in this, sir. You don't have experience in this. You didn't do all the calculations. That's how you would know the answer, is if you were able and qualified to do the calculations. Just based on your experience, nobody calls a cop out to a pedestrian crash where it's going less than half a mile an hour. Now, maybe that's not true. Maybe he has been out to it, right? But I get Jackson's point. He's trying to say your experience is with more catastrophic stuff.
Whatever that was.
Are you saying SUV was Lexus going half a mile per hour?
Well, you're the Reconstructionist. Give me an estimate of how fast you think that SUV was going at the point of contact with the traverse.
Maybe like 1-2 miles per hour?
Okay, fair enough. Have you ever been called in to a crash, to investigate a crash, where the cars have collided at 1 mile an hour?
I've had pedestrian crashes that have been at a very low speed.
Okay, that wasn't my question. That wasn't quite my question.
Okay.
My question is, have you been called in to a crash involving two vehicles
Yeah.
that made contact at about 1 mile an hour?
I have seen testing for vehicles at low speeds. So that's when I've been called to a crash. I go to fatality crashes, but I have seen testing for vehicles at low speed impacts,
Okay. How low speed?
like just the bump.
So like this?
Yes.
Did you see any damage?
Yes. All right. Well, minimal damage.
Right. In what circumstances? Minimal damage like, I don't know, like a cracked taillight.
Interesting. He did see minimal damage, like a cracked taillight. Lori, I agree. I think that, I got to be honest, I think a lot of times the vehicle data can be a lot more simple than what it sounds like in this case. I definitely agree with you. And Lizzie, I don't remember him saying that either, but I assume it's in the chart somewhere. But I was a little confused at that as well at first.
No, like just a little bit of rub off on the paint.
Right? Or you might see nothing, right?
Yes.
You've certainly seen circumstances in which two cars come in contact and there's absolutely no physical damage to either car, nothing observable, right?
Have I gone to car crashes? Have I seen no physical damage on a car?
Or just in common sense, just everyday life, where one car backs into another car at the Jiffy Lube, makes contact and drives away, and there's no damage.
Not normally. It's usually something with car and car impacts.
Like, what's the something?
Well,
A crack or
I happen to work on hundreds of car accidents every year. There are absolutely car accidents where there's no damage. Absolutely. Are they serious car accidents? No, of course not. But there are taps which leave no damage.
paint, something chip, scratches.
Right.
Yeah.
Always.
So if you put a piece of metal in that scenario, you put a piece of metal, steel, right, against a piece of plastic, which one do you think is going to give way first?
You'll still see some damage to both vehicles at a speed.
Which one would give way first?
Between metal, depends what speeds. And what we're talking about, you're just saying plastic and metal. You're giving a pretty general broad plastic and metal
Triple Paul,
analysis here.
you admit, you got to agree with me, that there are circumstances in which low speed, very, very low speed contact between two cars can certainly leave damage on one and not damage on the other, damage on both, or no damage on either one. Observe.
Yes, I just said in that situation where the scratch on the side of her car had a scratch mark and his doesn't appear to have anything.
And you said, under questioning by Mr. Lally, that certain circumstances like this could lead to a lens material, right, plastic material crack.
Say again, like at least.
Just a few minutes ago, Mr. Lally,
I'm trying to answer your question. Sorry, yes.
Mr. Lally asked you a question a few minutes ago, and you indicated that something might show up on a bumper. Something might, something might, like a taillight, might actually crack, correct? At a low speed impact.
The taillight might crack on a low speed impact?
Correct.
It might crack.
Okay, now, Mr. Lally also said, you saw this video where the cars come close to or make contact, right? That's how he worded the question. Remember that?
Come close. Yeah.
Which one is it? Did it come close or did it make contact?
I said it might. I don't know what if that scratch from the side is. It's something that's consistent with the height of the bumper. Like I said, I didn't measure them side by side, but you can clearly see there's a scratch on the side, and that's something that looks like that would come back. So as I look at the bumper, I see the bumper, and it has that little divot, and I look at her side of her car with that scratch mark. That kind of lines up a little bit of why that could be where that was from.
I thought you said there
That kind of lines up with a little bit like where that could be from. I like measurements. You know what's I've literally seen happen before? Like, you know how sometimes cars have either reflectors or even they have like a weird just piece of plastic that's for looks around, and then you have a scratch, and when you put them next to each other in accident reconstructionist and you can recreate it, you're like, oh, that little piece of plastic sticking out is exactly at the height of the scratch. Wonder why? And that's how we use evidence to prove things. Not like a little bit could have been like that. Yeah, you get it. Probably from the scratch.
no damage on that car, on the Traverse.
There is no damage, and that's why I went to why there's the two different paint materials there. That why one could have showed up on her car because it's that flat, the glossy paint on there, and it could have scratched on it. While you have something that's a little more rougher texture, with like a flat color on there. So that wouldn't leave on there.
So you just described the circumstance in which two cars come in contact. You don't see any observable damage on one, and you do on the other. That's what right?
Yeah, I suggested that when you asked me a second ago.
Yeah. With regard to the video, let's get back to the question that I asked, which was, in that video, did the SUV come close to, or did it come in contact with the Traverse?
Again, I don't know, because I'm saying based off the damage that is something consistent with that. So most likely it did come in contact with the bumper to bumper. But I don't know definitively because there is no damage to his car, but it's something that could explain why there's a scratch mark alongside the right rear side of his car, her car.
Did you see the tire move, sir? Did you see the wheel on the Traverse move in that video?
No, I couldn't see the wheel move.
I beg your pardon?
I didn't see it move. If I did, I didn't observe it moving. If it moved, it moved. I didn't observe it moving. I wasn't looking at the wheel.
When was the first time you saw that video?
I don't really know. It's been a little while.
Well, I don't know what a little while is.
Like a year ago, I think.
Okay. So you saw that video a year ago. Did you put anything about that video in your report, which is wherever it is, right there? I'm looking at your entire car's report. Did you put anything in this car's report about watching that video?
No, because I watched the video like after the report was done. And honestly, I watched it the first time on Court TV. So
who on Court TV?
First time you saw the video was on Court TV. Yeesh. Thank you, Rebecca. Thank you.
This trial?
Like no, when it was on TV at some point.
When did you and Mr. Lally have a discussion about you testifying about this video?
That was a couple weeks ago?
I'm sorry, I couldn't understand.
A couple of weeks ago?
What's a couple of weeks ago? Is it 10 days ago?
2 weeks ago? 2 weeks ago?
So he establishes basically that Lally has had this opinion for weeks and didn't disclose it to them. That's problematic. That's majorly problematic. And we're going to listen to the arguments from both lawyers here on what the judge should do with this evidence. And the judge ends up taking it under advisement, but he's going to leave. And now we get to hear the lawyers. The defense obviously wants to argue that it should be kept out. The state wants to argue that it should come in. Amy Lee, I need to go to bed is the last part a Brady vid? No, it is this stuff. Did the expert say GPS location? He used GPS to create that map. Did one of the people who tested the evidence testify the glass on the bumper didn't match the glass on the ground? Yes. But I thought some of it did. Some of it did, some of it didn't. I think that's how I remember it. Crypto tax lawyer, few objections during this clearly speculative testimony. I think strategic. I thought they dealt with this pretrial at motion limiting hearing. I didn't watch the motion limiting hearing because I didn't watch any of those prior pretrial hearings. Dalton, that makes absolutely no sense to me. With my 16 years of experience in law enforcement, I've never seen that happen where someone spins around after being hit. So here's one thing that this brought up to me. So I don't know. I guess that's plausible to me, but also I always thought he was hitting the front. So if he was hitting the front, did he do a 360 to land on his back? How did he hit a curb? Did he hit the curb and spin again? Like, is that physically possible? I need these answers. I need these answers. A lot of people asking about how this information with the snow and the tires spinning, That's up to the Commonwealth to explain to us why this still fits into that, even with those details. RS, do you think sometimes the defense lets Commonwealth witness testify outside their expertise because it looks odd and they can grill them on cross? Usually not, because it becomes record evidence that the state can then use and build on. So you usually don't want to let people testify outside their expertise unless they're dead wrong and you can hammer them on it and cross. Kathleen, wouldn't that head wound upon impacting the grass ground pool a half gallon of blood? Why only 6 drops? Kathleen, this sounds like an excellent question for an expert, a medical expert that needs to testify about this stuff. Lawyers can't just say it, right? Eric, I heard we get paid to be here. Just kidding. What's up, brother? After today, did the needle move for you in either way? No, I don't really think it was moved much today. They gave me a way to say, and if I want to throw out the house long to die in the cold, fine. But this guy was not as good as I was hoping if the state was going to prove their case. Has anyone ever checked John's car for damage? Yes, they've testified to it, and they said there was no damage in the area it would be. April, if they can prove she hit him in this way, can't they prove whether she hit the car in the same way? With the data, maybe. Katie, we love your analysis. Wouldn't this limited mileage contradict the prosecution's theory of her going somewhere else for a half hour in the morning? It's like they're just throwing out facts and details here and there and not connecting them all together. That's one of the problems. And that's one of the hard things about strategically thinking as a trial lawyer, and usually why you don't want to call 1,000 witnesses and make the case take 1,000,000 weeks, because it's harder to connect all this stuff together. Casey, thinking of you and your family with the rain and the flooding. We are doing great, Casey. Thank you so much. Irish X said, sorry if I'm repeating, but did the Reconstructionists take the snowy and slippery roads into consideration at all? I didn't hear him talk about that much. Peter, why is judge judging the evidence? Isn't she there to judge, to determine if the evidence is legally evidence? Isn't the wheel moving up to the jury? Name is Liki La Gushka. Rhymes with babushka. She is the gatekeeper and judges whether the evidence should come in or not, and whether or not the jury can even consider certain evidence. Katie, he insists the bumper would collide before the taillight, but yet John only had injuries supposedly from the taillight and not the bumper. Somebody else said, why isn't there injuries to his leg? MC, why are we not talking about the taillight being dark during his test, but completely lit up at 5 a.m. when she left the house? I've had people send me so many pictures and videos and screenshots, and it's hard for me to tell what's red, what's white, when it's lit, when it's not. So I have a hard time just putting all of my eggs in one of those baskets. Okay, let's listen to these arguments, and then we're done.
Do this. I'll hear you, Mr. Jackson.
Your Honor, it's very clear that this is a blatant violation. Commonwealth has at least the obligation to provide us with any new opinions that any expert's going to testify to on direct examination. They've known about this witness for not months, for a year, for a couple of years. They've known exactly what this witness has memorialized in his official report. They knew that the only thing that we had was the official report. They met with him 2 weeks ago. This has become a pattern of conduct by the Commonwealth over and over and over. We're finding these witnesses getting on the stand, finding out that there's been a sort of preemptive strike in some sort of a prep interview where they're coming up with new opinions, new conclusions, new facts. It happened with Jennifer McCabe. It's a new fact about coming up, going to Michael Lake's house. It happened with Officer Sarah, coming up with a new determination about what was said or not said.
New stuff keeps coming up at trial. He doesn't want to say it's an ambush, but it feels like an ambush.
A scene that we've never heard before. That was also a prep session of some sort, or I believe it was. And then this witness, literally, it's not even like just, was it like.
So Chance, I always love when people say this. Same thing happened to me. A guy rear-ended me in college when I had an F-150 and a hitch on it. His car was totaled and destroyed. Nothing on mine. He was on the phone with his dad. I felt so bad. His dad was screaming at him. He was screaming at his dad. I was like, I'm good. I'm going to go, bro, if you're good.
Light out, it was a dark out. This is a completely new opinion based on evidence that we presented.
He's right.
Or talked about in the opening statement and have presented variously throughout this trial. And this officer gets on the stand and now has a new central opinion about whether or not we're right. And that taillight lens could be cracked. That's something that should have at least been reduced to writing. And even if it was reduced to writing, it should have been excluded. Because it's a discovery violation. It's late. We don't have time to prepare for it. And we're caught off guard. I use the word sidebar ambush.
He's right. He's like, even some good information came out from us there. That's potentially Brady.
That rankles the court, and the court doesn't like it, but that's exactly what it feels like.
Well, that's been used both ways here, right? So it's a word. Let's just take it out of here. Make your point. Okay.
I'll see if I can come up with a synonym for it.
Well, I understand your argument. So focus on, just continue where you were, but no comment whether I like ambush or don't like ambush. It's a word I've heard a lot on both sides.
I understand, Your Honor. My point is the evidence that now is being sought should never be presented in front of you.
We're going to get to Lally.
Jury testimony was in his grand jury testimony. It was crossed about whether or not it was in his report, but it was in his grand jury
First,
testimony.
he responds to like the other stuff that Jackson argued with. I don't care about that. Let's hear what he talks about, why this guy should be able to testify to this stuff. This new opinion that he never disclosed, which is crazy to me. You cannot do that. I'm going to hold for the end of this. It's going to be the last part. I got to go.
There's no violation there. As it relates to, and why I say laughable, Your Honor, is that I am still...
I don't like hearing you say laughable. Just
Understood.
stick to what the arguments are. And
With respect to this witness...
Hold on. Quit the finger pointing, name calling, things like that, please.
Yes.
I know it's been a long week. It's been a particularly long day, but just focus on what you want to argue to me.
And I apologize to the court for that, Your Honor. With respect to this testimony, it's well within his realm as a crash reconstructionist. This is a witness who's responded to and investigated hundreds of crashes involving damage to vehicles, simply making an observation of contact between two vehicles or purported contact between two vehicles on a video. The force is self-evident, and whether or not that force is sufficient to cause the damage that he personally observed on the defendant's vehicle is well within his expertise. And should be permissible as far as for this witness to be able to testify to.
So basically his argument is this guy's an accident reconstructionist. He's got experience in this. He is reported to other crash scenes. The defense should know, obviously, he can testify to this stuff. It's no big deal. It's just some small opinion. It's like, no, it's not a small opinion. That's why you want to get it in. I actually agree. I think it's a great opinion for the Commonwealth. I think if the guy can say, no way this lines up, however he's going to testify if the jury buys it, I think that's really important information for the Commonwealth. They've known about it for weeks. Why not just disclose it? Do it the right way and get it in. Now that you've done it this way, it shouldn't come in. It's otherwise relevant, otherwise appropriate, but you didn't say it. That's like me saying this guy's a doctor. He's going to testify to this surgery. And I'm like, actually, he's going to testify to this witness's medical information and that witness's, and he's going to testify to this part of the body. And he has this opinion. I can have an expert that's just a, neck surgeon. And if he doesn't give me all of the neck opinions, then sometimes judges will strike it. And it can be the same specialty, the same body part, same person. You have to disclose all expert opinions to be prepared for and responded to if necessary. The judge takes it under advisement. I think there's no way this needs to come in. Like, no way. Justin said, sorry, this has been addressed, but why are the lawyers not required to state the reason? Is that the judge's discretion? Yes, and that's what this judge is doing. Assuming he's right, how did OJO get 10 feet from the curb? That's up to the Commonwealth to prove beyond a reasonable doubt. Mitzi asked the question before you got to him speaking on it, but this is crazy. Bumper protects from lighting, busting, but light is what they are claiming did John's damage. Kat, Peter, we doing another fantasy football league this year? Rough start last year, staying away from Rodgers for sure this season. Yes, we will, Kat. Rebecca, thank you so much for the kind words and for everybody showing up. That's all we got. The weekend has officially started a little later than I was hoping, but that's okay. Give me a like. Hit the like button before you guys bail. We got almost 18,000 people in here. Let's get it up. 18,000 likes if everybody hits likes. And please subscribe. Me and my dad did a Young Slime Life trial update on the motion to recuse the judge. It's wild. We get details from the secret ex parte meeting with Judge Glanville in that case. If you want to check that out, tomorrow, 8 a.m., subscribe, hit the reminder bell, and you'll get alerted by YouTube. It's all we got. Happy Father's Day to all the fathers out there and to my dad. Appreciate you guys. Till next time. Peace. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.